And I'm on.
There you go.
I have two requests to speak cards. If you want to speak, let's do that now. Come up here to the corner of the desk right there and get a card and fill it out, and then put it on the corner there next to Zach, and he'll hand them up to me. Anybody else want to speak? If you even think you might want to speak, just fill one out. Doesn't cost a thing. Okay, well, that's happening. We are in order, and we have no old business before us. We have a continuation of business, and we'll ask for the roll call first. Renee, would you call the roll, please?
Mr. Russell,
Here.
Mr. Price,
Here.
Ms. Denny, here. Ms. Gentlecore, here. Dr. Miller, Mr. Stroud,
Here.
Mr. Thorpe.
Here.
Okay, we'll just go right into the agenda. Tonight, we have a quasi-judicial comprehensive plan amendments hearing, and we're going to consider the modified lot split application with three associated variances. And it's for subdivision requirements for property owned by Michael and Colette DeChristopher. Thank you. And having said that, I'm just going to ask David or Zach, whoever is going to do the deed, to take us through the summary of what we're going to talk about tonight, and then we'll go deeper with the conversation. Anybody who wants to speak is going to get to speak, so don't worry about it. Zach? David?
All right, thank you, Mr. Chairman. Good evening, everybody. We have a whopper on our hands this evening with respect to just in a lot of different ways. And so I'm going to take my time as we go through this, and I'll go through as much of it as I think is important to go through. I think that I'm going to try to hit a lot of the highlights and a lot of the important matters that need to be brought up this evening. There may be a few items that I don't cover, but if there's anything that any of the board members want to discuss in any further detail, just stop me and we can discuss those.
Okay, David, before you get started, I want to put my 2 cents worth on yours. Tonight, I expect to hear a 10,000 feet high summary of the past events about this subject. Just fly us over the high level. Give us the highlights, but not the gory details. I think we're all familiar with the subject, or we wouldn't be here.
Okay.
We expect to hear a little bit of the history, and then we want to hear the agreements that have been made. I think you were going to cover that. And then we want to hear everybody make their case. But you play it the way you want it. Those are what I expect.
All right, Mr. Chairman, fair enough. I think I'll be able to accommodate you and the rest of the board. But because of the nature of this request and the complexities of it, I will maybe go into a little bit more detail than I typically do. But I just want to make sure the record is complete and the board has all the information that they need to make a informed recommendation at the end of when the time is appropriate. So, jumping right in. As the chairman indicated, that this is a consideration of a modified lot split application and 3 corresponding variance requests. And we'll get into specifically what all of that means here as I go through my agenda cover. The applicant owns 2, and you can follow along with me. I'm going to start right at the short summary of applicant's request. The applicant owns 2 tax parcels, and those are indicated with their ID numbers there. The tax parcels are only a portion of the originally platted Lot 21, which is in the Beach Gardens Unit Number 2 plat. The 2 tax parcels have not been approved by the city as separate lots for development purposes. Okay, that kind of that's the 50,000 foot thesis statement. Let's take
Have they
this.
they have not been platted, they have not been platted as lots?
Correct.
Okay,
We'll dig into that a little. We'll get down, we're at 50, we're going to move down to about 25 now.
you're going to show us some maps?
I am.
Very good, proceed.
The applicant initially requested, and if the board remembers several months, well, more than 7 months ago, but a while ago, this case came to the board. So you should be somewhat familiar with some of the general concepts and issues here. But we'll cover a lot of that. The applicant initially requested a lot split, seeking to have the two tax parcels in their current configuration recognized as separate developable lots. The initial request was denied by the City Council, and that was done through a resolution number 2022-32. However, so as not to deprive the applicant of all property rights, the resolution recognized the two tax parcels as one developable lot. Okay, that'll be important. This recognition is consistent with the City Council's original intention when it approved the plat back in 1962. Following the adoption of resolution number 2022-32, the applicant filed a request for relief, and that is an attachment. That's attachment 2 in your agenda cover. We'll go through that. This relief act is authorized in statute, and it claimed that the resolution that the council approved, 32, unreasonably or unfairly burdened the use of the owner's real property. Under the act, the applicant and city are required to mediate the applicant's claim before an appointed special magistrate, which we did. Under the settlement agreement, the parties agreed that the applicant could modify its lot split application, that was what came to this board originally, to request consideration and approval of the modified lot split plan, which we're considering tonight, which was attached to the settlement agreement, and 3 corresponding variances, which are being processed under Chapter 98. I want to talk about that just briefly. Typically, our boards deal with variances that are in Chapter 110, which is our zoning section of code. And a typical variance would be, hey, I want to build my house 5 feet from the property line. Code says I have to be 8, so I want to ask for a variance of 3. That's the typical 99% of the variances that we process go through that process. And that goes to the Board of Adjustment. That's the only board that's involved in that. However, Chapter 98, which is our subdivision regulations, has its own variance process. And that process requires this board to consider the application, which we're doing tonight, and you will make a recommendation that will go to the City Council, which will happen at their August 15th meeting. So,
Say again, exactly what the special magistrate meeting gave permission to do.
yeah, that's a good point.
Say that again.
I-
Where exactly are they entitled under those positions?
I'm going to jump ahead to page 3 of 6. If you want to follow along, please do so. At the top of the page, 3 of 6. At its April, and I'm answering your question, Lamar. At its April 18th, 2023 regular meeting, the council approved the settlement agreement related to the special magistrate proceeding. This is the important sentence. The settlement agreement did not formally approve the proposed lot split and corresponding variances. Rather, the settlement agreement allows the applicant to present the proposed modified lot split plan and hardship variances to the P&Z Board and City Council under the process in Chapter 98. So it didn't approve anything, it just opened the door for the applicant to request the needed, required modified lot split plan and the 3 variances. Does that make sense?
Yes, and
All
now
right.
go back to where you were before I
Okay.
interrupted.
So back to page 1. Second paragraph from the bottom. The proposed modified lot split plan request, if approved, would authorize the creation of 2 developable lots from the remainder of Lot 21. And we'll get to what that means, the remainder of Lot 21. for purposes of constructing a detached single-family home on each of the 2 proposed lots. So if the board remembers what I just discussed earlier, when the council approved the resolution, they approved 1 developable lot, 1 home on 1 developable lot. What the modified lot split plan is requesting is to recognize 2 developable lots. Okay. The proposed single-family home, on each of the 2, both lots will meet the minimum 7,500 square foot requirement for R1 zone property, which this property is zoned R1, which is the most restrictive zoning district that we have in the city, residential. The proposed single-family home on the proposed northern lot would be oriented towards Ridgewood, and the proposed single-family home on the proposed corner lot would be oriented towards East Central. Okay? So I'm going to jump around in some slides. Let's go to the slide that shows the modified lot split plan. Okay, keep going, please. Keep going. Keep going. Keep going. Keep going. One more. Okay. This is the modified lot split plan that the board is considering this evening. And I just want to make one point, and then we're going to kind of go retrace our steps. The modified lot split plan shows 2 lots, a northern lot, which is 62.02 feet in width by 125 feet in length. Does the board see where those numbers are identified? Okay. Now, the southern lot or corner lot is 117.81 feet in length or depth, excuse me, and the width is 90 feet. Okay. Now, I want to point out one thing is that these lots are oriented, towards Ridgewood. Okay? That's how we determine the width and the depth of these lots.
Where do you see the width of the southern lot? Where do you see that width?
It's on the western property line. It says 90 feet.
Okay, I see
Okay?
it.
Now that's important because the lots
Okay.
are, the lots are oriented towards Ridgewood. Now, when we get into the settlement agreement, you're going to see that one of the things that was stipulated in the settlement agreement was the orientation of the structures. So that's different between the orientation of the lots. The orientation of the structures, the structure on the north lot is going to be also towards Ridgewood Avenue. So the lot and the structure will essentially face or front or be oriented towards Ridgewood. The corner lot, while the lot is oriented towards Ridgewood, the structure is going to be oriented to East Central Avenue. The structure is. And we'll talk a little bit about why that is. That's an important point, okay? Let's go back a couple of slides, please. A couple more. Let's see, what's the next one? One more? Okay, we'll stop there. Down to the last paragraph on page 1. If the proposed request is denied, City Council Resolution Number 2022-32 still provides that the 2 tax parcels will be recognized by the city as 1 developable lot. We've already discussed that. And I'm going to just move on from there. Let's go to background on page 2. And I've already talked a little bit about this, so I'm not going to get into too much detail. It's kind of a rehash of the short summary on page 1. On December 20th, the City Council approved the resolution that we've been talking about, denying the applicant's lot split, however, recognizing the 2 tax parcels as 1 development parcel. The applicant's original application sought to have the 2 tax parcels recognized as 2 developable lots. The tax parcels were never approved by the City Council and were not recognized by the city as separate developable lots due to a previous unauthorized subdivision of land that occurred in circa 1984. The tax parcels together only constituted a portion of Lot 21. Okay, let's stop right there. If you see what's in the audience and the board, if you see what's on your screens, this is the original plat from 1962, when the city was in its infancy. This is one of the original plats. Now, what we're talking about is parcel 21. Does everybody see that? It's on the corner of Central and Ridgewood. That lot, can we go to the next slide, please? Yeah, oh, yep, there we go. There's a blow-up of the plat. Notice the dimensions on these three plats. These are important. We've got 125 feet in width on 19 and 20, and 150 feet in width on 21. The depth of these lots were all 152.02. That runs north-south. Okay? Let's go to the next slide, please. Okay. Those three lots were divided into 7 lots by a previous owner, by a gentleman by the name of Charles Pinziak. That division, that unlawful division, as the staff report indicates, was in 1984. Okay? Now, what this is showing some dimensions, which is important. If you remember, the original lot 21 on the corner was 150 feet in width. These new lots, the ones that are shown with the MCD, which is Mike and Colette de Christopher, you notice now that it's only 125 feet in width. What happened was that westernmost 25 feet of the original lot, lot 21, the 150-foot lot, that 25 feet of that was carved off, and it was joined with, I'm not going to get into all the detail, but the 5 lots to the west of what Mr. de Christopher owns, due to a reconfiguration and some additional unauthorized divisions, the 2 lots were basically was reconfigured into 5. So we had 3 on the original plat. Today we have 7. Okay? Mr. de Christopher owns 2 of the 7, and those are shown MCD. Mr. Pinziak still owns 5 of the 7, and those are indicated with the CHP. All right? Okay. So, moving on. Let's see, where do I want to pick up? Let's just pick up in the next paragraph. On January 12th, 2023, shortly after the adoption of the resolution, which we've been talking about, which denied the applicant's request for a lot split, the applicant timely filed a request for relief, which we mentioned earlier, which triggered the special magistrate process, and that's when Mr. Gugelman, who was mutually agreed upon to be the special magistrate, that's when he got involved. The special magistrate process can be invoked by a property owner who believes that a development order issued by a government unreasonably or unfairly burdens the use of the owner's property. And I won't go into any more detail on that paragraph. In furtherance of complying with the act, the applicant and the city agreed to the appointment of Mr. Gugelman, which we did. We went through the process, and Mr. Gugelman issued a development order, and the order approved the settlement agreement. And these are all attachments which we'll go through. So there's a development order, and then there's the stipulated settlement agreement. They're 2 different documents, but they go hand in hand. The order further set forth a variety of deadlines and contingencies depending on the outcome of future decision by the council. So you can kind of consider the order, how I look at it, the development order, which we'll get into, basically is a procedural document. It says what has to be done and when it has to be done by. It sets a bunch of deadlines. Whereas the stipulated settlement agreement gets into a little bit more of the meat and potatoes of the actual request and more of the specifics on what the lots, the configurations, and it includes some of the agreements between the city and the applicant. Okay, so at its April 18th, 2023 meeting, the council approved the settlement agreement. and I won't read that again, but again, it did not formally approve the lot. The settlement agreement does not approve the lot split. It just allows the applicant to request a modified lot split plan and hardship variances. In compliance with the settlement agreement, the applicant submitted a modified lot split plan on May 16th, 2023. The proposed modified lot split revises the previous submitted lot split plan, which was denied by the City Council, and also that modified lot split plan requires the consideration of 3 variances to Chapter 98 requirements, and we're going to go through each one of those real quickly. The first one, Section 98-107B3, requires that a corner lot have a width of at least 15% larger than the width of an interior lot along both adjacent streets. So, looking at the aerial we have in front of us right now, you can see that the proposed lots that Mr. DeChristopher owned, not the proposed lots, the tax parcels that Mr. DeChristopher owned are 125 feet in width. In depth. The width is 76.01. Can we go to the next one? Next one? Next one? This one right here. Okay. Again, the northern lot is 62 feet, and the southern lot is 90 feet. Okay? What this section of code is saying is that that corner lot has to be at least 15% larger in width than the adjacent lots. Now, if we go back, can we go back again? I'm sorry, I'm jumping you all over it. And one more. This one right here. Oh, no. You can see the width of that adjacent lot to the west is 100 feet, okay? The width of the tax parcel on the corner is 90 feet. If this requirement says that you have to be 15% larger than the adjacent parcel, that would mean it would have to be 115 feet in width. Hope everybody's following.
You lost me.
Okay.
The,
Our subdivision regulations in this section of code says that the corner lot has to be 15% wider than the adjacent lot to the west. Okay? The adjacent lot to the west is 100 feet in width. If we apply that 15% larger rule to 100 feet, that means that that corner lot should be 115 feet in width to meet that requirement under paragraph 1.
So, Dave, I think the confusion is
Okay.
that the graph that's up there in front of us shows
Yes.
125 feet.
Yes. Let's go back to the, that's the depth. The 125 feet is the depth. So that, one more, please. One more. Oh, back the other way, I'm sorry. One more. One more.
all right, let's
Right
be
there.
a little clearer about what is width and what's depth.
Okay. Because, remember I discussed earlier that the lots are oriented towards Ridgewood. So the width of the northern lot will be 62 feet. The depth is going to be running east-west, which is 125, okay? As well as the southern corner lot, the orientation is east-west, so the width is 90 feet, and the depth is 117, give or take, okay? Does that make sense to everybody?
It does make sense, but I have a question. Why, like, it appears when it was the original subdivision, your width was the 125 and your, depth was the 2 lots together. Now,
Yes.
doing this split, we're reorienting the lots?
Yes,
From the original?
that is correct. The orientation of the original plat was the same as all the others, to the south towards East Central. That would be a result of the request, would be a reorientation of the 2 parcels towards towards Ridgewood. And the structure on the north lot would be towards Ridgewood, and the structure on the south lot, parcel, proposed parcel, would be towards East Central. So yes, it is a reorientation. Correct.
And that's just to try to make sure to optimize this lot split?
Well, I think we'll get into, I'll answer that question. We'll get into that a little bit later on, but to answer your, I'll attempt to answer it right now as well. One of the things that we're attempting to do here is maintain consistency and compatibility in the neighborhood from a lot and from a structure orientation standpoint. Can we go back to,
Stay there. Wait a minute, I got some questions for you.
okay,
So if I'm looking at that north lot, the width of it is 62, and the depth of it is,
125.
yeah, okay, where am I? Okay, you gotta do some.
Gotta do some
Okay.
searching.
So the depth of it is 125, the width is 62. But going down to the southern one, southern lot, the width changes.
Yes.
You're now looking east-west for the width. It's 17 feet, right?
The width is 90,
Okay.
which is over on the west. It's just where 62 is, but it's just below it.
If you're looking at the orientation, the width of the lot is the width across the
Remember,
frontage.
right, remember the lot is oriented towards East Central, or excuse me, towards Ridgewood. So if that's the case, then the depth would be run east-west.
Yeah, but he's going to face the house south. So then the width of the lot is 117 feet, and the depth of it is 90 feet. Everything switched when you reoriented the house.
Well, that would appear that way, but there is nothing, there's nothing that says that the orientation of the lot has to follow the orientation of the structure. So they can be independent of one another.
So what are we talking about tonight? What's the width and what's the depth? Just what is it on the application?
On this, the width and depth of the southern corner lot, the width is 90 and the depth is 117. The width and depth of the northern lot is 62 width, 125 depth.
Just a real quick question, Dave. As we're going through this, is it possible to apply for a change in the orientation of the southern lot?
Is it possible to change? Yeah, I think, like, as I mentioned, there's really nothing in code right now that says that a corner lot, if you think about a corner lot has two front yards. And there's nothing that's in code that really speaks to you will orient your corner lot this way or that way. As long as you meet the zoning, as long as you can meet the frontage and width requirements, you can orient your house any way you'd like to. Either way, excuse me.
But as I remember, that wasn't the only issue, right? It
No.
was also,
No, there's
okay.
two more.
Okay.
Yeah.
All right, good.
And that's the purpose of the three variances.
Okay,
Okay?
thank you.
So the first variance, oh, did someone mention my name? Okay, I'm sorry. So that's the first variance, is the 15% rule. The proposed corner lot is not 15% larger than the adjacent lot to the west. So they need a variance to that requirement, okay?
So what's the 15 feet, what's the dimension with 15% added?
It would be
150
115. They would be required, to meet that requirement, they would be required to have a width of 115 feet. And they only have 90 feet as shown. So that's the purpose of that variance. Number two, section 98-107A talks about that minimum R1 lots have to be at least 75 feet in width and 100 feet in depth. Well, as we've been talking about, that northern lot, it meets the depth requirement because it's 125 feet. However, it's only 62 feet in width. R1 zoning requires 75 feet in width. So that's the second variance request, is it's not meeting the minimum R1 width requirement of 75 feet, the northern lot. Okay? And the third variance is which basically states that double and reverse fronted lots should be avoided. It's not a prohibition, it's just saying they should be avoided. As indicated on the modified lot split plan, the proposed corner lot would be considered a double frontage lot as it has frontage on both Ridgewood and East Central Avenue. Okay, so corner lots are considered double frontage lots, and the code is saying they should be avoided. So that's the third variance request, is a variance from that should clause. Those are the three variances. Has everybody kind of had their head around those three?
Go over that last one.
Okay.
Should be avoided, double frontage lots.
Double frontage lot. Yes, sir. Okay. Let's go to page 4 of 6, the lot split. Remember, we're here discussing a modified lot split request and 3 variances. So we've talked about the lot split, the variances. Now, the lot split section is in chapter 9866 of the code, and there's a number of criteria that the code spells out which we should review these lot split requests against. And so let's talk about each one of those. A, the proposed lot split in every respect meets the criteria found in chapter 98. And elsewhere in this code and the city chapter, and the city code and this chapter, which is 98. Staff comment is, as proposed, the modified lot split plan does not meet certain subdivision regulation minimum requirements, and we talk about the 3 again, which we've discussed. However, the applicant has concurrently applied for 3 variance requests. If approved by the city, will address the identified deficiencies. So we've identified 3 deficiencies. They're the subject of the variance requests, and that is that criteria. Criteria B.
Now, go over the 3 deficiencies.
Well,
One of them is 25 feet less than needed. One of them is 13 feet less than needed. And the other one is the double frontage.
yes, those are
Okay.
the 3 deficiencies. Criteria B, the application is consistent with the city's comprehensive plan. And the response is, should the applicant's variance request be approved, the proposed modified lot split plan will be consistent with the city's comprehensive plan. So it's kind of a conditional yes. C, the application does not create any lots, tracts of land, or developments that do not conform to the city code. And again, it's the same response to A above. The application provides for proper ingress and egress, which the modified lot split plan does. So that's D. E, the application is compatible and in harmony with the surrounding neighborhood, including size of the surrounding lots, development trends, which have been previously approved. Staff response, the surrounding area is characterized by single and multifamily residential development with a variety of different existing lot sizes. The size of the proposed lots are generally consistent with the existing variety of lots in the immediate area. If you look,
Now go back just a
Yep.
second.
okay,
All those answers were, yes, we agree with the city's code, but they were conditional on the variances being granted. Did I get that right? You went through three questions there,
Yeah.
and each one of them met the code. But there was an if attached to the, whether or not it met it. The if was the variance, right?
right. If the variances are approved, then we can answer in the affirmative to,
Okay, just want to get that straight.
yes. Now, if you look at the square footage of the proposed lots on the slide that we have on our monitors, you can see the northern one is approximately 7,500 square feet, or 0.17 acres. And the southern one is 9,500 square feet, or 0.22 acres. Does everybody see that on the plan? Okay? Yes, thank you. Excellent. Perfect.
Go ahead, I'm looking at that one you got on the screen. The southern lot, just looking at it, looks bigger.
Oh, it is. It's 1,500 square feet bigger. And there's a reason for that. Yes. Anthony? Hey, Anthony, would it be okay if I handed out the spreadsheet information? Okay.
0.17 versus 0.2.
And, yeah, let's keep a few copies back here in case anybody would like one. Mr. Chairman, Kyle is gonna hand out a spreadsheet that we did that kind of looks at some of the lots in the area. And it gives you addresses and it gives you acreage. And you can see there's a various, I don't want to call it a hodgepodge, but there's various lot sizes in this area. And these are all single-family homes that you're looking at as well. If you go across Ridgewood, you have some very higher density multifamily. You have, what's the name of that name of that project? You have Ocean Woods directly to the north. You have the Manors over on the beach. Yeah. So you've got, if you can just in your mind's eye kind of take a mental tour of that area, you really do have a mix of both single family and multifamily. You've got a number of townhouses to the south of this as well. Between the school and this property, there's a number, on Cherry Down Lane and some of those areas, there's a lot of townhouses that are on very small lots. So around the immediate area, it's mostly single family up and down East Central. But as you extend out just a little bit, you really do get a mix of both housing types and lot sizes.
Excuse me, but as I think about that, you have to go, 3 or 4 lots west to get into developments, right?
Yes.
On both sides of the street.
Yes. If you would, could you go back to the where we have the initials on the parcels? Yeah, right there. Yeah, that's right. You can see what John's talking about is that is true. Now, it's important. I also want to point out too that if you look at this area, you can see the orientation of the homes on East Central. They're all towards East Central. Okay? That's important. And also, if you look at the orientation of homes on Ridgewood, let's hand these out. I'm getting ready to Kyle's going to be handing out an aerial of properties along in this general area as well. And it zooms out a little bit further than what we're looking at here on the monitor. But you can see some of the homes in the southern portion of that aerial, the ones that front onto Ridgewood. They're all oriented towards Ridgewood. They access onto Ridgewood. And that's important. I wanted to point that out because the homes the lots, the parcels that front East Central access East Central. The homes are oriented towards East Central. The parcels that are accessed and oriented towards Ridgewood, the homes are oriented towards Ridgewood. And that's essentially what the applicant, I'm not here to make his case for him, but I'm just kind of stating facts, is that was a result of the mediated settlement agreement that had a big part of why the lots are oriented the way they are and why the structures are oriented they are, to meet and be consistent with the surrounding development patterns and trends. Okay? All right. So I'm back to the lot split criteria. C, the application does not create any lots, tracts. Okay, we've already talked about that one, I'm sorry. We've talked about D. We just finished talking about E. F, the application does not create burdensome congestion on the streets and highways. I think based on the nature of the request to create 2 single-family lots, I think we're comfortable in saying that it's not going to create any adverse impact on the local road network. So, and we have a few more criteria. I'm on the top of page 5 now. The application promotes the orderly layout and use of land. This is an important one. The proposed modified lot split will allow 2 detached single-family homes to be constructed consistent with existing uses in the surrounding area. Also, the approved settlement agreement requires that the proposed lots be oriented towards Ridgewood and that the structure on the corner lot be oriented towards East Central Boulevard, consistent with other homes along East Central Boulevard. H, the application provides for adequate light and air.
Go back.
We can answer in the
Settlement
affirmative.
agreement said the houses had to be oriented how?
The stipulated settlement agreement states that the structure on the north property line, north parcel, has to be oriented towards Ridgewood.
Yeah.
Why is because the other homes that are on Ridgewood are oriented towards Ridgewood. The home on the southern or corner parcel must be oriented towards East Central, consistent with the other homes along East Central.
So
That's-
these houses are to be oriented this way if the variances are granted and the,
Yes, all of this is contingent on the variances.
all right,
Yes,
all right. Okay, go ahead.
okay. I, the application does not create overcrowding of land. Again, these lots are both 7,500 square feet, which meet the minimum R1 zoning district requirements. J, the application does not pose any significant harm to the provision of water, sewer, and other public services, which will not be the case. They will not have a negative effect on those public services. Okay?
Dave?
Yes.
I thought we had talked about the northern lot
Mm-hmm.
not meeting the requirements in terms of width and depth.
It doesn't. However, it meets the area, the square
Meets the square footage,
area,
okay.
square footage area.
Okay.
Correct. Now, the northern lot does meet the depth requirement of 100 feet.
Okay.
It's 117, I think,
Yeah.
or 125. Does not meet. The only thing it doesn't meet is that width of 100, width of 75.
70, oh, yeah.
Yeah.
Okay,
Yeah.
all right.
Okay, variances. So we've talked a little bit about the lot split. The criteria we just discussed were associated with lot splits. Now, variances. As the requested variance relates to design, let me read that again. As the requested variances relate to design requirements established in Chapter 98, which is our subdivision code, there is a separate variance process in Chapter 98, okay? And I think it's important to read this. Chapter 98 provides that a variance to the city subdivision regulation can only be approved when it is determined that, 1, strict compliance with said regulations will create a hardship, and 2, by approval of the variance, substantial justice may be done and the public interest secured. Okay, so those are two concepts that we've got to keep in our mind as we're looking at these. Now, Chapter 98-4, which is in our subdivision code, it actually gives us some specific criteria that we need to be looking at as we're considering the variances.
Can I interrupt 1 second? I'm sorry. So it says strict compliance with said regulations will create a hardship. How do we define hardship?
We'll get to that.
Okay.
That's a good question, and we're going to get to that in just a second. I'm going to read, this is the last sentence in that second paragraph. In order to authorize any variance, it shall be found that all of the following factors exist, and it goes 1 through 6. Let's skip to attachment 7, which is a variance analysis worksheet, if you will, and it goes through each of these 6 criteria. And this is important. So let's jump to attachment 7, which should be towards the back of maybe the last 3 or 4 pages of of the packet. Okay, I'm going to read some of this verbatim. I apologize, but this is important stuff. In addition to the is everybody there? Okay. In addition to the application submitted by the applicant and other testimony received by the P&Z board this evening, the following information is provided to assist the board in its evaluation of whether the applicant's request meets applicable criteria. And let's define a hardship. This is to John's point. Is whenever the Planning and Zoning Board finds that hardship may result from strict compliance with this chapter, based on applicable criteria and requirements set forth in this chapter, it may recommend to the City Council that the regulations be varied so that substantial justice be done and the public interest secured, provided that such variance will not have the effect of nullifying the intent and purpose of the comprehensive plan or these regulations. Okay, so I thought there was a specific definition. Oh, here's hardship. We'll get to that in criteria 4, John. Okay, we'll define what a hardship is.
I still haven't heard.
Okay,
What's the hardship?
Let's read that right now. I'm jumping to criteria 4, but it's contained in there. In section 98.1 of code, this is in the subdivision section, hardship is defined as an unnecessary inability to use the applicant's land in accordance with the zoning ordinances and laws or land use ordinances which exists due to conditions or circumstances peculiar to the applicant's land and does not result from the actions of the applicant. Okay? All right.
That's key.
Now-
Does not result from the action of the applicant.
Right. Now, these criteria that we're going to
is it
go through, these 6
self-created?
criteria are going to help you answer those questions that we just tried, that are contained in that definition. Okay? So the first criteria, variance worksheet, requested variances, da-da-da-da-da. Let's go to page 2 of this, and we'll go to criteria number 1. All right? Top of page 2, and it starts at generally. Is everybody there? Okay? Generally, in order to address the lot split and variance criteria and to propose a solution to the dispute, the applicant proposes a modified lot split plan that orients the proposed 2 lots towards Ridgewood, orients the proposed single-family home on the corner lot towards East Central Boulevard, maximizes the corner lot size in order to maintain harmony with other lots along East Central Boulevard, and maintains the minimum 7,500 square foot lot size requirement for both proposed lots. The proposed modified lot split plan requires consideration of the aforementioned variance requests. Okay, here we go. Special conditions and circumstances exist which are not applicable to other lands, structures, or buildings in the applicable zoning classification, or R1. The City of Cape Canaveral subdivision code has always technically required the division of land into 2 or more parcels to be platted. However, in 2010, the city adopted an exception to the city's platting ordinance, consistent with Florida statutes to permit lot splits, which are generally a division of land into no more than 2 parcels. Lot splits are adopted by the city council by resolution rather than as a plat. Notwithstanding, some property owners in Cape Canaveral prior to 2010 apparently subdivided their land by recording deeds with the clerk of the court without notifying the city and following the city's subdivision requirements. Staff has not been able to find any records indicating the applicant's 2 tax parcels were authorized by the city. This unauthorized division by a previous owner which occurred in circa 1984, resulted in the creation of 7 new tax parcels that are vacant, including the 2 tax parcels owned by the applicant. These 2 parcels were sold several times before the applicant acquired them in 2018. The 2 tax parcels together only constitute a portion of the original Lot 21, which we've talked about, and no longer comply with the city's subdivision standards. So these 2 tax parcels no longer comply with the city subdivision and zoning requirements. Okay? And for large part, in large part because that westernmost 25 feet was removed and it's under a separate ownership. It's actually owned by the Mr. Pinziak, who did all of these illegal subdividing in 84. Additionally, the subject property is a corner lot with 2 frontages, which required the corner lot to meet a larger 25-foot setback along the 2 property lines, rather than 1 for a typical lot with only 1 frontage. The subject property also has a curved radius along the southeastern corner, further constraining the size, location, and dimensions of a future building envelope. The general area contains lots which are zoned R1 and have been developed with existing single-family homes over the course of several decades, even though the city has no records of these lots being approved by the city. In addition, while there are 5 other vacant tax parcels that were created from the unauthorized splits by Dr. Pinziak, the city is not aware of any of these tax parcels being sold to other parties. So from our records, and what we're trying to do is we're trying to answer number 1, the criteria. Special conditions exist which are applicable to these 2 parcels that are not applicable to other parcels. So the 7 tax parcels which we're looking at on this monitor, only 2 of them have been sold. And those are the 2 that are owned by the applicant. All right? Number 2, the special conditions and circumstances do not.
Stop.
Okay.
So you've read through the special conditions under 1.
I'm sorry, what was that?
So you read through all those conditions under number 1 here on page, it doesn't have a page number.
Right.
Should always number pages.
I know.
Put this stuff together.
Yep, I agree.
Been preaching that for years. So what's the conclusion? You read through all these wherefores and whereofs and additions and generals and
Yeah, Lamar, I'm not sure.
I don't want to get lost in that. I mean, what you come through all that, led us through it, we read it, we considered it. What's the conclusion? What's it telling us?
Well, I think what we're doing here is we're expressing some facts as staff sees them.
Okay,
We're not making the conclusions. That's really, I think what we're doing is just spelling out the facts for the board. And the board is going to have to make its own conclusions and arrive at its own decisions.
yeah, and I think we're getting lost in facts. But
Well,
go ahead, and I'll try to
okay.
be patient.
I believe what we've done is in the staff response, we're indicating and showing how these 2 lots perhaps are. There are special conditions and circumstances, as we've discussed here, that
Yep.
apply to these 2 parcels. Now, I think we're kind of bringing you to the water.
Go ahead.
Okay. Number 2, the special conditions and circumstances do not result from the actions of the applicant. And let's see now. And the response is the special conditions and circumstances do not result from the action of the applicants. See staff response to criteria 1 above. And what we've done in 1, if you look at the response in 1, which is right above, which we've just talked about that, we've talked about how these illegal lot splits happened in 1984 prior to the current owner purchasing them. In fact, they've gone through several owners since then. So there are several intervening owners between 1984 and when the applicant purchased the properties in 2018. And if the applicant would like to get up and speak to that when he or his representative have a chance, they can further elaborate on that if they would like. All right. Number 3, granting the variance requested will not confer on the applicant any special privilege that is denied to other lands or structures in the identical zoning classification, which is R1. Staff's response is, should the lot split and variances be approved, the petitioner will be authorized to construct one detached single-family home on each of the lots. Each of the lots meet the 7,500 square foot requirement for R1. The detached single-family, and we talk again about the orientation of the homes, how they, as stipulated, they'll be consistent with the development trends in the area. So I think what we're suggesting is that to kind of bring it more focused, the response, I think what we're suggesting here is that if all of this is approved, the applicant can build a single-family home on each of the lots. And that's what you find in the general area is detached single-family homes. Number 4, literal interpretation of the provisions of these regulations would deprive the applicant of rights commonly enjoyed by other properties in the identical zoning classification. All right. Let's we talk a little bit about a hardship. We define hardship. The 2 tax parcels owned by the applicant were created under conditions or circumstances peculiar to the applicant's land and not resulting from the applicant's actions. The history of the subject land is described in detail in attachment 1. The general area contains lots that are zoned R1 and have been developed for residential purposes, even though the city has no record of many of these lots being approved by the city. Does everybody understand the significance of that statement? Okay. Should the modified lot split plan and subject variances be approved, the petitioner will be allowed to do what other folks have been allowed to do in the general area, is build a detached single-family home. Number 5, the variance granted is the minimum variance that will make possible the reasonable use of the land, building, or structure. If the board is inclined to approve the lot split plan and associated variances, they are the minimum needed to maximize the corner lot while maintaining the minimum 7,500 square foot lot size requirement for both proposed lots. And the last criteria, the granting of the variance will be in harmony with the general intent and purpose of this chapter, and such variance will not be injurious to the area involved or otherwise detrimental to the public welfare. Again, this is a single-family, detached, immediate area, R1. The lots are generally 7,500 square feet or larger in this area, and that is what is being proposed through the modified lot split plan and the 3 variances. That is consistent with the development trend in the area. Another stipulation is that the homes will be a minimum of 2,000 square feet, which is similar to other homes in this general area. And that's really, so if we jump back to attachment, I know the chairman wanted to go into a little bit more detail into the development order in the stipulated settlement agreement. So if you go to attachment 3, that is the conditional mediated settlement agreement. And again, what I mentioned is that yes?
I really don't think you need to go over the conditional mediated settlement agreement.
Okay.
Nor do I think you need to go over the special magistrate's order laying out the timeframe under the Land Use Dispute Act.
Okay.
The bottom line is, the conditional mediated settlement agreement approved by the city council allows the applicant to modify his application and present the modified lot split plan and 3 variances to the city council for consideration. Your role is simply to review the modified lot split plan and the 3 variance application requests and provide a recommendation to the city counsel. That's all that mediated settlement agreement provides. There are a lot of technical, legal issues, but they don't concern the board. Just focus on the modified lot split plan being applied for by the applicant and the 3 variance requests, and make your recommendation to council. It's that simple. Thank you.
I think that concludes my presentation.
Okay. We're looking at the variances. And one of them's asking for 25 more feet, and the other one asks for 13 more feet. And then double frontage is, that's see and saw, but you can argue that. But the 25 and the 13, that's a pretty good amount of variance. But anyway, we've heard the facts. Those are the facts. So I think we should now hear from the applicant, let them make their case. And anybody else, we'll get to everybody else that wishes to speak on the matter. Ms. Rozanski, you can come forward. Are you Mrs. or Miss? Mrs. Okay.
25 years in October.
Very good. Welcome to City of Cape Canaveral Council Chamber, and make your case.
Thank you, Chairman Lamar, members of the Planning and Zoning Board. My name is Kim Rosanka. I'm with the law firm of Lacey Lyons Rosanka in Rockledge on US 1. I'm here on behalf of the DeChristopher's. I wasn't before you when this came to you on August 2nd of last year. It's almost been a full year. I understand it was a very long hearing. It was involved, confusing. There were 6 residents that spoke against the lot split, just the lot split, no variances at the time. And you did ultimately recommend approval to City Council. And City Council heard it, it got tabled, things happened, and it went back in December, and that's when I came involved in December of 2022. So I don't know what happened here exactly on August 2nd, but we're back here to try to resolve it. Again, I love the phrase that was used, substantial justice may be done, and with the interest of, and the public interest is secured. There's nothing here that the DeChristopher's are asking for that others in the neighborhood don't already have. And I don't really understand all this opposition, except some people I think just want the rules to be followed because they had to follow the rules, and I understand that, but things have changed since 1962 in the city of Cape Canaveral. What I would like to start with is a larger version of what the picture that was shown to you, and I have a handout for all of you.
Thank you.
This was, I just prepared this today. It is, I like red markers, I don't know why. But the 2 corner lots on the right-hand side, those are the 2 lots at issue as they exist currently. These were purchased by the DeChristopher's in July 2nd, 2018 for $420,000. He was told that they were 2 developable lots by a realtor, and he went through the process of trying to develop them and found out he couldn't. And I can go into that if it's interesting to you, but I think you may have heard that a year ago. The ones that are marked with P are the ones that Dr. Pinziak still owns, and they are undeveloped, as you will see, because they too were illegally split. Every property and house that has an X on it are also illegally subdivided. This is a prevalent problem within the city. The city did attempt to resolve it a few years ago. It was during COVID. I don't know what happened, but the city council determined not to pass the grandfathering ordinances. But most of this was done back in the 80s, and lots of people got building permits, but all of these have in their legal description something that shows a lot split, an illegal lot split that was not approved by the city. I'd also ask if you look at the Canaveral Beach Boulevard, the far left properties with the X's, Those are two lots that are very similar to the ones we have here. You have the one house that has the driveway onto Surf Drive, and then the other, to the south exits onto the other road. But those are also houses that didn't quite fit and didn't have variances. We're trying to do this the right way. Mr. Christopher was told by the city that after the fact lot split was the way to do it. So that's why he came to you in August and went through the city council process. In fact, after he bought the property, he went to city staff and he was told he had 2 lots of record, but they may have been illegally subdivided. Then he was also told by staff a little later that there were a lot of numerous illegal lot splits in Cape Canaveral Beach Gardens and around the city, and they were going to try to do an ordinance to correct the illegal lot splits. Then again, a year ago, Mr. Christopher was before you. Mr. Kevin Markey was his attorney at the time. And at that time, staff recommended to P&Z and to City Council to approve the lot split, and you all did actually recommend approval of the lot split. Back then, the staff and even the city engineer at the time, Mr. Allen, came to the conclusion the lots were consistent with the code and met the criteria established in 98-66 for the lot splits. And that was before you when you approved it. There's been some change to that because of this 15% larger, the corner lots, and that's why this was resolved at mediation I was not a part of, to make that one corner lot a little bit larger, so the variance requested was even less than what it would have to have been if he had the original lot split before you. I do want to call your attention to chapter 100-1 of the code definitions, and it does allow that lot dimensions and definition for width. Width of a lot shall be considered to be the distance between straight lines connecting the front and rear of the required setback, provided, however, that width between side lot lines at their foremost points where they intersect shall not be less than 80% of the required lot width. And although this doesn't actually say that you can do, that it's almost like a waiver, that you can have 80%. So if you look at this definition of lot, we're asking for a 15% reduction, I believe, to get to the 90 feet. And I may be mistaken with my math, but I believe that there's other code provisions that provide for this variance of that corner lot width that the city has determined is to be 115 feet. I believe that's. So a variance of 25 feet. So yes, that corner lot, city staff has determined needs to be 115 feet. We're at 90 feet, a variance of 25 feet. And we believe the definition of lot could indeed allow for a 20% reduction. That wasn't addressed, and I didn't write the staff report. I haven't discussed that with Mr. Dickey. He may disagree. Again, Mr. and Mrs. DeChristopher are wanting to buy 2 homes. One is for his brother and one is for himself. He has tried to go through the process, went to city council, went through the statutory request for relief, and we're here with that modified lot split, which is before you in the, I believe it's on the screen right now. Yes. And so we're here for the lot split application. In order to get the lot split application, if you approve it, you have to approve the variances first. I believe that it's not clear to me, but I think you have to agree that the variances are meeting the criteria, and then if that, you would agree to the lot split. The variance worksheet that's Mr. Dickey read to you, Mr. Russell, I believe as Mr. Dickey said, he's led you to the water, but I think this actually does support, now he hasn't said he recommends approval, but the facts do support every element needed for a variance, for these 3 variants. That 3rd variance is odd, but they've asked for it, I think, just to clarify, because every property is different. So every variance request is different, and every development building permit is different. So I think city staff was trying to make sure everything that could be challenged, the suggestion that you don't have it on a double frontage lot. I think that's why the 3rd variance is there. But if you go through the worksheet, the special conditions and circumstances exist which are not applicable to other lands. Again, this is an unusual lot split. It was one lot 21 that was split into 3 pieces. We don't have that anyplace else, even in that diagram that I show you. I don't believe there's any of that were like that. They were just cut and pasted from other lots. So this was actually a triple lot split by Mr. Penziak, Dr. Penziak, back in '84, long before the DeChristopher's even thought about getting involved in the city of Cape Canaveral and building in the city of Cape Canaveral. So he sets forth the conditions, and Mr. DeChristopher also filed a worksheet that sets forth even more reasons to grant the variances. But this is what the city staff has done, and I argue that this does indeed support every criteria. Special conditions do not result from the actions of the applicant. Again, he did not split this. He bought this after several other people had owned the properties and likely ran into the same problems that DeChristopher's did. But again, he spent $420,000 on these 2 lots in 2018, being told by his realtor that he could build on these 2 lots. And again, staff initially thought that he could, and then said, well, there may be an illegal subdivision. Let's try to work through this process. The granting of the variance will not confer on the applicant any special privilege that is denied to other lands or structures in the identical zoning classification. It will not. In fact, many of these illegal lot splits already have houses. So if he's not allowed to build on these lots, he is being treated differently than all those other X's on the property on that sheet that I gave you. A literal interpretation of these provisions would deprive the applicant of rights commonly enjoyed. Again, staff lays it out, defines hardship, unnecessary inability to use the applicant's land in accordance with the zoning ordinance's laws. Each of these lots meets the minimum requirements of 7,500 square feet lots. They're going to be compatible by the requirements of that they're faced different ways, the north lot to Ridgewood and the south lot faced to the south. Number 5, the variance granted is the minimum variance. The proposed variances are the minimum needed to maximize the corner and the minimum needed to allow both lots to be buildable. The granting of the variance will be in harmony with the general intent. Again, the staff report states surrounding areas characterized by a variety of single and multifamily residential. You see from the picture, there's single family in this area. The proposed modified lot split and variances will not result in development having an adverse impact on the local road network, water, sewer, and other development services, public services, and will promote the orderly layout and use of land by maintaining the minimum 7,500 square foot lot requirements and orienting the homes as I just discussed. Again, that is a statement of support from staff. It is a fact, but it's also an opinion that the criteria is met. The last paragraph of the staff worksheet, the proposed modified lot split will facilitate a use consistent with the single-family residential use in the immediate area. The size of the corner lot was maximized. So again, just regurgitating what has been said repeatedly by staff, that the modified lot split plan meets the criteria for the modified lot split that's been requested. With that, we would ask that you approve the variances, the 3 variances that are stated in the staff report. The variance of 25 feet to the required width of the 115 feet of the proposed corner lot. A variance of 13 feet to the required width of 75 feet for the proposed northern lot. And a variance to the provision that the creation of double or reverse frontage lots should be avoided as it relates to the corner lot. If those are approved, then I would ask that you approve the modified lot split as it meets the criteria of 98.66 as gone through by Mr. Dickey, the A through J, and again, also as referenced in the variance worksheet, that it is consistent and compatible. And Mr. Dickey did say, I'm sure it's in the 70-page document, but he did say that this is compatible with the comprehensive plan, which all development orders from the city must be. So with that, we believe that the applications before you for variance and lot split do meet the comprehensive plan and do meet the requirements of your land development code, and ask that you approve the variances and the lot split. And we're here to answer any other questions. I know there's a lot of information before you, and I know you've gone through this a year ago. So hopefully what I've said will help clarify a few things. And Mr. DeChristopher is here as well, if you have questions for him.
We will hear from everybody. Okay, stand by. I'm going to ask members of the board if they have any questions for you, Counselor. And so I'll start with Mr. Stroud. Do you have anything?
No questions, Mr. Chairman.
Mr. Thorpe, do you have anything you'd like to delve into? Okay. How about you, Mr. Miller?
No questions.
Susan?
No questions at this time.
Okay. John Price, do you have any questions?
No.
All right.
I have no questions, but I do have a statement. I'd like to thank the staff for doing such a fine job of preparing the documents for us. There's a lot of stuff to wade through, and you made it palatable anyway.
Thanks, John. How about you, Mrs. Gentlecore?
No comment.
Okay. I'd like to thank the staff for doing all this work, pulling all this data together. We waded through a lot of facts. Normally, I try to keep us from getting lost in facts and overwhelmed by all the data. And I generally demand that we cut to the chase. But this thing has a lot of facts surrounded the issue. But what it boils down to me is he's got 2 lots. He's got enough land to give more than the required 7,500 feet for a lot size. He can make 2 lots greater than 7,500, so he's got the property. It's just a matter of how it's configured and how it's used that's in dispute. Before we go on, and I'd like you to remain in place, Counselor. Let's see, let's hear from Kay Jackson.
Thank you very much for allowing me to speak. And I have to say, Mr. Dickey, you did a great job of laying all this out as well. That's a lot of work. I want to voice some concerns about, and our city attorney is the expert, not myself, but I have questions about what legal precedence this sets. Because when you look at that color diagram of or the color photo of the lots, those lots that are on the west side of these 2 lots that are going to be split, but on the north side of those have no road access. So if we allow this lot split now, what kind of precedents will we set for if Dr. Pisniak ends up selling those to someone else and someone has that northern lot that's northwest and not on a road? There's no road on those lots the way he has them split up.
Right, you are.
So that concerns me because I'm really afraid that we'll end up spending our tax money again here in the city, going through this again in the future if we allow this lot split. If you look at the neighborhood on Central, those lots, one long lot, has 1 house on it. They have large yards. So although it may align with a lot of the, the ordinances that we have and all of the legal aspect of it as far as how it's defined, when you look at these other ones, we've got a potential of having a big mess on those that have no road access. We have that westernmost lot that doesn't have enough square footage for it to be built on. And those can be sold as well, and we'll end up going through the same thing as a city, using our resources here with our staff and taxpayer dollars. So I don't understand the hardship of you buying a lot. It's unfortunate that this was an illegal lot split in the first place. That's the unfortunate part for the person that bought it and that kind of thing. But being a real estate investor for over 30 years, it truly to me is a buyer beware. And I'm not sure why we are trying to deal with splitting this at a city level when this is clearly something that should be taken back to the realtor that sold this and said it could be split, and Dr. Pisniak that did an illegal redefining of the lot without the city's approval. So here we are spending taxpayer dollars now when we as citizens didn't create that situation. And you guys are doing a great job of handling this. I'm impressed with the information and all of that. But truly, I would really beg that we don't split these lots, because we're gonna go through this again, and as taxpayers, we will end up paying for them again. This same scenario, but even worse, because we've got 2 lots back there that have the right dimensions that have no road access. And that means utility easements that will not be there. Those are power lines behind those on the north side. So I would be concerned if I approved this, that I would be setting a legal precedent going forward, that we're gonna have to do all kinds of things to honor this agreement that was not agreed upon by the city back in 1984.
Are you a realtor?
No, sir, I have been an independent investor in real estate for quite some time.
Okay.
And I'm also a condo association manager and deal with properties, but I've dealt with purchasing investment properties in multiple states.
I wasn't trying to impugn your, your opinion. In fact, I was going to pull on your expertise.
I like to
And,
read.
yeah, and let me now stand by. I'm going to redirect the question to the city attorney. Regarding those lots to the west of the lot we're talking about tonight, those landlocked lots, if you sell those, if one sells those, isn't one allowed or supposed to grant access or find access to an internal lot? How can you sell an internal lot without access? In other words, are we
I think it's buyer
creating,
beware, you know, and everyone does their own due diligence, but the city code prohibits landlocked parcels, right, Dave? That's correct. So, you know, those were illegally created by deed,
doesn't
but
state,
they don't have road access.
doesn't state realty law prevent landlocked property, or does it not? Doesn't address it?
I don't think
It's a
Freck gets
question.
into that.
I don't know if we've got the answer in the room tonight.
I'm not sure that's like a
But-
relevant question.
If we approve the ordinance or recommend approval for the variances, are we creating a mess down the road is the question. I don't want to do this again.
Well, I would refer you to the exhibit that the applicant's attorney provided the board. You know, there's an issue. There's been an issue in this neighborhood and other parts of the city. So will the city ever have to deal with this issue again of illegally subdivided lots? Again, I refer you to the exhibit. I think she missed a couple of X's along the way. But, you know, you're gonna the city's gonna deal with it again.
Yeah.
And that's one of the reasons why this board recommended an ordinance change, but the ordinance wasn't adopted by council, so.
Yeah, this is an issue all over the city, and we've got many, many, many lots that have been illegally subdivided.
Well, when I look at the spreadsheet, the acreage for all these lots, it's all over the landscape. It varies from .17 to .24, and everything in between. And I forgot my multiplication on this. What is the minimum lot size? What's the minimum acreage?
7,500, I don't have a calculator.
7,500 square feet
Yeah,
is.
divided by 43,560, whatever that number is.
Yeah, whatever that is, but, okay, yeah, it's getting farther than we need to go. But he's got the property. He's got enough property to make a decent size, two good-sized lots, over 7,500 square feet. It's greater than our requirement. But the other considerations are, are we creating a mess for those other lots that are sitting there just waiting to be treated the same way? And I said I didn't want to do this again. We'll do it if we have to. But there it lies. How does what we do today affect those properties? It's going to have an effect on them monetarily and neighborhood.
Well, I think when you worry about creating a precedent, you have to look at the circumstances and the conditions that surround the situation in front of you. I mean, the two landlocked parcels are just that, landlocked. They have no access. The two parcels in front of you this evening do have access. They do have frontage on city-maintained streets. So the landlocked issue distinguishes the two this evening to those specifically. Regarding the larger issue of all of these illegal subdivisions or divisions that have occurred through the years, like Anthony said, we attempted to fix it, but that the council didn't move forward with that particular ordinance. Again, the distinction here is these two lots these are the only two of the 7 that are not owned by the gentleman that made the illegal divisions in 1984. I'm sure we're going to have discussions at a staff level on what to do with both the remainder of these 5 parcels as well as pieces of property around the city, because we don't want to go through this on a regular basis.
We will if we have to. Let's don't put anything in concrete, but it'd be more pleasant if we didn't have to do it again. Okay, so we've established one thing is that these lots, the lot configurations did not result didn't happen as a result of the owner. He got that. Can we establish that, asked another way, can we establish that the shape his lots are in and the condition and what we're dealing with didn't happen? He didn't make it happen. He just got it, right? So that's one of the conditions of the hardship. It can't have been created by the owner.
Yeah, I believe we discussed that in the agenda cover. We point out certain facts that indicate that these illegal subdivisions occurred prior to, and in fact, several owners previous to the current owner.
Okay, so the owner didn't do this. Okay, that's one fact. The other fact is that the lots are bigger than the minimum lot size required by code. But they got that way by variance to adjust the dimensions.
Well, no, without the variances, the two lots exceed 7,500 square feet.
Okay,
Now, the variances are just to deal with not the lot size, but the configurations of the lots. That's where the variances are needed for the configurations.
tweak the dimensions.
Yes.
Okay. As a result of this conversation, have we tweaked any other questions in the panel?
Yes, I have a quick question. The properties that Dr. Penziak owns, he owns 5 properties there. Those properties in the rear, those lots in the rear, it's always going to be landlocked, so there's never going to be a way around that. If Mr. DeChristopher is approved and does his building on his 2 lots, then it would be up to Dr. Penziak to figure out, he's either going to have to do some plottage where he's going to have to sell multiple lots, or he's not going to be able to put a single family home on those rear lots because there's no roadway.
That western lot is too small, is it not?
we continue to use a term that he illegally subdivided. He didn't subdivide anything. He had tax parcels, and you can sell tax parcels any size or dimension you want to. That's not illegal.
Okay.
So what he sold to Mr. De Christopher was a tax parcel under the understanding it had been subdivided, and it hadn't, but he did not subdivide it. He sold a tax parcel. Now, Mr. Penziak owns these tax parcels that we see in the diagram. They're not subdivided. They're just tax parcels. And he can sell them any way somebody wants to buy them. But what happens is we have to sort out the platting and the lot sizing and the subdividing. So, well, sooner or later, Mr. Penziak's going to have to face that issue.
Right, the city does not recognize Mr. Penziak's tax parcels as a developable lot.
Of course.
So like you said, Mr. Chairman, that's like spot on. That's what I was gonna say is, it's a nice picture on the diagram, but until the city recognizes what the dimensions are of the developable lots, they cannot obtain a permit for development, technically.
And that's what we've been wrestling with tonight. We're dealing with the dimensions and deciding whether or not to allow the adjustment of dimensions and making the lot officially platted or to be platted. And these other tax parcels have not been. They haven't been given that treatment.
But without the split, the lots become like the other lots on Central that are similar, and all of those issues are no longer issues, because the 1962, I believe you said it was, plot map showed those as developable lots that were long and deep. And so if we went by what the actual legal plot map was, none of this would be an issue. It's the
That's true.
splitting of the lots that it's becoming an issue.
Right. All right, so,
And wouldn't that be what is actually legal for the city? Is the 1962 plot map?
let's just stop there. I'm not sure where we are
Okay.
legally and philosophically. Let's just stop there and not continue wading into that. Let's deal with the variances and the lots at hand.
Thank you for your time, I appreciate it.
Okay, appreciate you too. Let's see, we got another speaker in that one. Let's see, that was Kay. Pat, you're up next. Mr. Campbell?
Patrick Campbell, 307 Surf Drive, Cape Canaveral. I'm here to speak in opposition of this lot split for various reasons. I think I might be the one that actually has kept this alive. If you recall, it was first brought to you as a correction to the sins of the past, and let's change the ordinance to protect the innocents who, through no fault of their own, have gotten themselves in a bad spot. That's how Mr. Dickey first presented it to you when he was asking for the ordinance. And then we find out that the initiator for that discussion, that exact discussion, change the ordinance, was Mr. De Christopher. At the same time, Mr. Dickey talked about the fact that this is not about developers coming in and doing this, and this is not about building two homes on two lots. And now what you're finding is, it is exactly that, and it has been for a couple of years. First, try to get the city to just grandfather everything in, where they do what they want. That didn't work. Why didn't it work? Well, because the ordinance wasn't necessary. The ordinances that we have today cover this. And it does talk about illegal lots, and those illegal lots can only be remedied within the terms of our ordinances. The young lady who talked about the rest of the neighborhood, I brought that to you, and I have furnished you multiple pages of things supporting my opposition. But one of the other things Mr. Dickey said, that this is not a widespread issue. When you look at where this is, it's 33% of my neighborhood that could change based on what you decide today. We talk about landlock. Well, if you look, gee, why did that 25 feet get peeled off? How wide is a driveway? About 25 feet. Mr. Penziak already has a flag lot established. If you go down a little bit further south on that graphic that's on the screen, you'll see that he's already marked a flag lot. So this is not happenstance what's going on. That property was originally zoned C2. It was turned into R1 to preserve some residential property in the city of Cape Canaveral. I have an expectation that means something. And the attorney talked about, what is the opposition and is it just because I want the rules followed? Absolutely, I want the rules followed. That's what I expect out of the city. That's what I expect the ordinances are for. I've said before, the ordinances are not suggestions. They're not things that you try to figure out a way around. They are the expectations of the community you live in. When we talk about facts, and I love talking about the facts are, this was brought to you as an ordinance change to protect the innocents. The facts are that Mr. DeChristopher is a seasoned real estate broker and agent. Mr. DeChristopher is a developer. Mr. DeChristopher is a builder. Those are the facts. He's not an innocent. When we talk about what is the hardship, a hardship is created because he bought the property. Now, he claims that a real estate agent told him he could build on it. He is a real estate agent. There is a due diligence requirement here. He bought it knowing there was a cloud on his ability to build two properties. He created the hardship. The Burt Harris Act and the piece of it that they're layering in here now, the request for relief, was never intended to allow somebody to go in, make a mistake on how much they pay for a piece of property, and then come expecting the city to figure out a way that they can capitalize on it and maximize their investment. That's not what it's for. That's what it's being tried to do here. Plus, money, what you spend, is not a criteria for hardship. That's clear. Another clear in the case law is if you buy a property, you are expected to be aware of what you can do with that property or it's on you. He created this hardship by buying it, knowing there was a cloud on it, only to say a realtor told him he could build on it. Well, the clerk at 7-Eleven told me you can't. That has the same weight. This group, our city council, decides based on the ordinances what can be done with that property. The other things that I like to talk about, I just think, and I've said this all along, this is procedurally and factually incorrect. This is not a lot split. Never has been. So I would encourage you to read what a lot split is. This is not that.
Well, tell us, re-educate us. If it's not a lot split, and I thought it was, tell me, what is your view of what is a lot split?
And one of the other times I came to speak, you hit on it. What are you supposed to do? You're supposed to plat it. That's what you're supposed to do. Then if you want to split it, you have a plat, split it. The lot split says it's going to be turned into no more than one property. What lot are you splitting? Tell me. That was my question all along. What lot are you splitting?
Are you saying the lot has not been defined yet?
No. There's never been a question Mr. DeChristopher owns 2 parcels of land. There's a question about what he can build on that. And we've tried to layer in all of these confusing elements when it isn't that difficult to figure out what's going on. You can't build on them because they don't fit. I've said that before, over and over again. You first were told things, but not the whole story, and you sent it back to the city council, and I pleaded, and apparently I was effective. That's why we're here today. Because you didn't have all the information. You didn't have the facts. You weren't told the truth. And now we continue with that by saying, well, if you just do these variances, then everything's in line. The problem with that is, if you follow the rules, one of them says, everything will be in compliance with this and all other pieces of the code. One of the other pieces of the code says, I'm going to read it so I don't get it wrong. Whenever the sections of this chapter are out of variance with the requirements of any other lawfully adopted rules, regulations, or ordinances, the most restrictive or that imposing the highest standards shall govern. So when we talk about can you approve a variance to the width of a lot, the answer is physically you can do anything you want, but if you're following the rules, you cannot. That was brought to this group in 2014 for another lot on Central, East Central, where a developer wanted to do exactly the same thing. Split it and build 2 homes. It was determined to do that, you'd have to change the width. You'd have to get a variance. You can't change the width. It went back. Mr. I think Green at the time put out a memo saying, well, before we do this, let's take a real close look at this variance issue. Be sure we get it right. Nothing was changed. So you can't change the width. The highest standards shall apply. So this whole thing about changing the width, you may be able to do it, but the rules say you can't do it. So that takes that completely off the table. You have to have these variances to make it work, and we've gone from everything's fine to a whole list of variances that have to be approved to allow this to happen, when in fact, you shouldn't allow it to happen. This isn't in place to allow a developer to come in and chop the place up and end up affecting 33% of my neighborhood, because that's what it'll do. Penziak's already got a flag lot, trying to head that direction on that entire piece of my neighborhood. Cut it up into small pieces, maximize the profit. There's always been an undercurrent of wanting to turn it back into C2. Okay. Well, if we can't do that, then let's just chop it up and put more than one house on the authorized lot size. Kind of the same thing. We talk about it doesn't affect the infrastructure. Well, yeah, it does. You're doubling the density at a minimum. You're doubling the density. So I do want to clarify one other thing that I'm not sure everybody's aware of on this. The mediation, and the attorney will have to step in and help me. This is before you today. So let's pretend you say, okay, send it back to city council. And city council says, no. What happens? You know, what happens is then it has to continue in the form of a mediation in a public forum. So nothing's being decided here other than, is this going to be presented to the public by the mediator? What you have before you today was done without any observation of the public. Done behind closed doors, confidential. You can't get any information about how this was decided. If you say no tonight and council says no, then it comes before the public so everybody can hear all that I've been talking about. That's what will happen with this. If you agree it and council agrees it, Mr. Christopher goes off and does what he wants and sets the tone for the rest of that neighborhood. If you don't, it goes back to the council. If they don't, it goes to a public venue. And no matter what.
What's the public venue? Does it come back here in front of this
No,
board? or is it-
mediation hearing. And the
Mediation
attorney can
hearing.
Step in and help me with that.
Okay,
If then it's just a mediation hearing. We have the mediation hearing. The mediator recommends, again, do this. It still has to be approved by the council. The mediation is non-binding. So it's just one more piece of the convoluted story behind something that is a relatively simple question. And that question is this appropriate to put two homes on that lot? It is not. It doesn't fit. The variances don't apply because you can't do it in accordance with the code. So I'm asking you to do the right thing, do what it says, say no, send it back to the council, let the council say no, and then have this out in public, so when we do make a decision, it's based on everything, not something behind closed doors, not some misinformation or misdirection that's been done before.
What are you suggesting?
I'm suggesting that the development order be in place and we build one home, as it should be on that property. I'm suggesting that this is not a lot split, that everything about this is flawed. I'm suggesting that the only thing you can do now is say no, send it back to the council. That if you do anything else, it's just more in a string of flawed procedure, flawed facts.
Any other question? Mr. Miller, do you have a question? You look like you're thinking.
Well, I'm thinking, but no, I don't have a question at the moment.
Okay.
I want to say something else about Dr. Penziak's lots. It's going to be very difficult for him to sell those landlocked lots because, any realtor that tries to sell someone that property, split up in lots like that, it's going to be a problem with the roadway, as the other lady suggested.
Point of order. We're talking about the two lots at the end, not Mr. Penziak's property.
Well, that's what I'm getting to, is that what Mr. Penziak does with his lots is not the issue.
We'll deal with that when the
Right.
time comes.
When the time comes, I agree. I'm saying right now we're dealing with Mr. DeChristopher's situation, and he doesn't have land that's landlocked. It's on the corner. And other than that, I'm trying to find out what really is the problem besides the 25 feet.
Well, the problem is that the variants you're being asked to approve aren't allowed by code. That's one of the problems. Can't build it without the variances. That's another problem. Why? Because that's the way that was laid out. That's why the orderly use of land clause is in effect. So there is an expectation to the rest of the neighborhood about what the neighborhood's going to look like, not what a developer's going to come in and convince you to do.
Mr. Campbell, we might want to clean up our terminology. I'm guilty of it too. It's not that variances are not allowed. They are allowed by the code. It's in the code. Variances are allowed, so let's get that straight.
Well, okay.
You just got to do it right.
Let me help with that because, I was told that again, you can do it. I'm not going to physically prevent you, nor could I, but the code says the highest standard shall apply.
Exactly.
And in 2014, this issue came up and it was determined you can't change the width with a variance.
Oh, I've got experience of 30 years that shows we've done that. It can be done, has been done, so you can change a width, you can change a property
2014,
doing
that
it.
question came up because it was stopped on a property and you were involved in it. It was stopped on a property on East Central, and it was stopped because you can't apply for a width in a variance.
Okay, let's debate that offline. Variances are allowed. I mean, you
The highest
gotta
standard shall
allow
apply.
that. Okay, let's try to make some progress here. We've got all the facts in front of us. And Mr. Campbell, I really appreciate the facts you've laid out for us. You help us cut to the chase, and that's admirable. Thank you for doing that. I'm not dismissing you. You can stay in place. Are there any other questions for Mr. Campbell by the panel? Okay,
Thank you.
looks like we've come to the end. Now, it's time for us to make a recommendation to the, and I'm going to ask for, yeah, I'm going to come back to Kim. I'm going to go to the city attorney too on a procedural question. But Ms. Counselor, please come forward and speak to us again. Go to the mic and say that again.
Okay, you're referring to me, Counselor, not Mr. Garganese.
Well, you're a counselor too.
I know, but I wasn't sure because you said you're going to him first. But yes, thank you, Chairman. Again, Kim Rosanka on behalf of the DeChristopher's. I want to try to explain why this is a lot split because Mr. Campbell has raised this over and over again. And all you have to do is look at the warranty deed. This was an improper, they call it illegal because it wasn't approved by your code, split of lot 21 from the original 1960-something plat. That's why it's a lot split. Mr. DeChristopher and Mrs. DeChristopher, they don't have control of all of lot 21 right now because Mr. Pinziak kept some of it. So the DeChristopher's 2 lots were cut from lot 21. So this is almost like an after-the-fact permit. When someone puts a fence in and they didn't get a permit, they have to go back and get it. That's why we're here. This is how Mr. DeChristopher was directed. So if you look at the deed, parcel 1 is the north 76 feet less the west 25 feet of lot 21, block 9 of Cape Canaveral Beach Gardens, unit number 2. And then parcel 2 is lot 21 less the north 76 feet and less the west 25 feet of lot 21. So that's why it's a lot split. That's what we're trying to properly do, a lot split that wasn't properly done in 84. And lot splits are allowed by your code. So that is why we're here. So Mr. Campbell says it's not appropriate to put 2 houses on what was believed to be 2 lots. Mr. DeChristopher will testify if you want him to. He did not know that these were not buildable. All he had to do was look at the neighborhood. All he had to do is look at all of these lots with the X's that had the same sort of less and except from lots that were platted back in 1962 or 64. So this is what was expected. This seemed to be rational. He bought 2 lots, paid a premium for 2 lots, seemed acceptable. So it is appropriate to put 2 houses on 2 lots. This is not a flawed procedure, what we're doing before you. This has been approved by your city attorney, approved by your city manager, supported by city staff, gone through a mediation process, which has been completely misrepresented by Mr. Campbell. And so we're here today. The mediated settlement really only allowed us to come back and ask for these variances under the same application to modify the same application. If this isn't approved at City Council, we go to another public hearing, a special magistrate hearing, where the standards are completely different than under general standards for asking for development orders. The standard that we will be going under for the special magistrate hearing, not another mediation or a public mediation, a special magistrate public hearing, will be whether the actions of the city in denying the lot split was unreasonable and unfairly burdened this property. And I would suggest to you that it is, because all of these other lots got to do what Mr. DeChristopher is trying to do. Regarding Mr. Pinziak, these properties, Mr. DeChristopher has filed 31 code complaints against all of these improperly split lots. And those are pending. At some point, all of these property owners are going to get notice. If one of these houses with the X is blown down, torn apart by a hurricane, more than 50%, I'm assuming most non-conforming, they're non-conforming because they don't have a proper lot. One of those houses are torn down, they're going to be back before you too doing the exact same thing because they might not be able to be rebuilt. So this is an issue, and I may be misstating your code, Mr. Garganese, but that's general law, that if you don't have a proper lot, you have a non-conforming lot. And variances are the appropriate remedy to fix a non-conforming lot. It makes them conforming. So that is why we're here. And I believe this has been addressed, but again, Mr. and Mrs. DeChristopher's lots do have frontage. They have access on both lots. They're not those northern lots by Mr. Penziak that have no legal have no access. There is a Florida statute 704.01 that does deal with statutory way of necessities and implied ways of necessities. So there is a legal remedy if those were legal lots, but they're not. So yes, every lot is supposed to, but currently if someone went in and asked for a building permit, they would not get one. They'd be on notice. That's all I have in the way of rebuttal. I think you all understand the issues. I know you've been through this. I appreciate all your time on this. I do too appreciate staff and Mr. Garganese spending quite a bit of time on these issues. It's been going on now for well over a year. So thank you. With that, I would ask that you approve the variances and approve the lot split.
Thank you, Counselor. Okay, now I have a procedural question for the city attorney. When we decide to take a vote, should we vote on the variances alone and then vote on the, what's next, the development order? What comes about after, what comes into play after the variances are approved?
Yeah, procedurally, I think the board should consider the variances first, because you cannot approve the modified lot split plan unless the board thinks that they've complied with the variance criteria. As Dave indicated, a lot of the facts apply across the board to all, each of the variances. So I don't know, it's up to the board whether you want to take them one at a time, or alternatively, all together. If you take them all together, you may have a disagreement on one or two. So you'd have to split them out anyway, so it might be better to just take them one at a time.
Next question, if we were to vote for approval of the variances, do we then have to go and vote for approval of the development order? We got to vote on it. Do we automatically have to vote on it?
If the, yes, you need to vote on the modified lot split plan. Okay, so if you were inclined to approve the variances, then I would think that, there would be an approval in order for the modified lot split plan. If you were to recommend denial of the variances, then you would have to recommend denial of the modified lot split plan. Because the
I would think if
modified
we-
lot split plan cannot survive without the granting of the variances.
I would think if we voted to deny the variances, we wouldn't even need to vote on the lot split plan. It dies, doesn't it? Okay.
I would procedurally ask you to, if that was the decision of the board, I would still ask you to vote denial of the modified lot split plan.
Okay, 1, 2. Either or. Okay. Now I'll ask the panel, shall we take the variances one at a time? Seeing a yes, a nod,
I have a question.
yes.
If we vote and say everybody agrees that 2 of the variances are fine, but we can't agree on the third one, what happens?
Good question.
I have to cross that bridge when we get to it, because it has various contingencies.
All right. Are we ready to vote? Or do we have any more discussion to be had?
Yeah, I guess I just want to say, this whole thing has been going on for a long time, right? The first time it came to us, we didn't have all of the information. And at that point in time, it was submitted a lot split plan, and you wanted to have a variance that was dug in there. And at that time, we said, you're only voting on the lot split, and we'll come back with a variance later. And then, of course, then it went up to the city council, and a lot more data was provided and all that. I mean, I probably wouldn't have voted for the lot split in the first place if we knew all of this data. So I just wanted to say that. It's, I think that,
Okay, that's where you're at?
that's
All right.
where I'm at, yeah.
Can I comment on that?
Yes,
I just want to make sure the board is really clear on on this point. The first time you heard this, it was a different lot split plan, okay?
It was, yeah.
Mr. DeChristopher was coming to the board requesting recognition of his tax parcels as is, as a developable lot. And then there was the 15% rule that came up after the board first heard this. And if you recall, it came back to the board and you examined the 15% rule. But your first recommendation for approval was based on the tax parcel configurations without considering the 15% rule. Okay, so that's all in the past now. So now what you have before you is a totally different plan. And just keep in mind, I just want to reiterate these points because it's in the stipulated settlement agreement. You know, these are two different lots that are being proposed. Yes, they require variances, but there's also other conditions that, you know, it's the lots are oriented towards Ridgewood. However, the southern lot that's being proposed, the house would have to be oriented towards East Central. In addition, both homes have to have a minimum of 2,000 square feet. Okay, none of that information was even presented for the first go around. So you got different I just want to make sure I emphasize there. It's a different it's a modified application, but it's a different application for your consideration. And while you may have voted on the prior one, I would recommend that you consider this application independent of your previous decision.
Okay, we'll treat it independently. My proposal would be to take the third variant, I'm calling it the third variance, the one about the orientation. Would you, David, would you dig into the paperwork and tell us where that is and we can vote on it? What, I want to just put it, yep.
Mr. Chairman and members of the board and the audience, if we go to page 6 of 6 on the staff report, I think we try to spell it out pretty clearly there. And I think I believe what you're asking for, Mr. Chairman, is kind of some direction on how
We're going to vote to recommend approval or disapproval
what you're
of that
voting on.
variance.
Okay.
Now,
Yes.
before you say that, Mr. Campbell wants to make one more statement. And come to the microphone, please. Normally, I would say we're done, but we're a small group. We're more informal tonight, so let's hear it.
A lot of discussion about the variances and the question about whether or not you can prove a deviation to the width of a lot. I'm going to read from April 9th, 2014, from David L. Green, city manager at that time. On September 11, 2013, the Planning and Zoning Board approved a request, the Doolittle case, to amend the definition of a variance to allow for a reduction to the minimum width of a lot. I'll skip down to the last sentence.
We had to do that. You're not putting the right context on it. We were forced into that because there was non-conforming substandard 16-foot lots that were built along Central years and years and years ago, and people lived in them, and we had to make those sellable. And that's why we did
I would
that.
respectfully request that you actually look at what went on in 2014. This was about a lot they wanted to cut in half.
Well, maybe
Exactly
that's a
what's
different
being done.
case, but that's,
Yeah, it's a different one.
that's
It's,
why we did.
30
The first time we adjusted lot sizes was when we had to treat those 16 feet wide little
This doesn't have
condos.
anything to do with that. This has to do with a lot that the developer wanted to cut in half to put two houses on a single lot. Essentially the same thing on the same street. Again, it was about requesting, changing the ordinance to allow a variance to include a variance to the lot width, which it did not allow. And Mr. Green's answer back was, if a more comprehensive approach to the variance process is desired, this is the time to get it right. To that end, it is suggested the Doolittle agenda item be pulled. Long story short, the ordinance did not change from that time forward. So my assumption is that it was looked at and decided that a variance to the width should remain, not allowed, because that's what generated this document.
Say that last sentence again, the variance to the width, what?
The inability to change by variance the width of a lot remains. You can't do it. That's what generated this 2014, was a request to change the width of a lot.
We did, well, we need to argue this offline, but we have changed the width of a lot in this town by ordinance, review. We went through the entire P and Z ordinance and reviewed it, and we changed lot sizes.
I only have what I found on Central that pertains to the property that's in question and the variance before you today. This document said you can't change the width of a lot.
And I'm only telling you.
It was never changed.
Okay,
from
I'm
that
telling
time
you my past experience.
And I do have the audio recording of that meeting if
Okay.
you'd like me to submit that.
Mr. Chairman?
Mr.
Yes.
Chairman, I think we need to clarify what Mr. Campbell is attempting to do here.
No, I think Mr. Campbell made that comment at one of the other prior hearings. Dave, correct me if I'm wrong, and I think we went back and looked at the minutes in that, whatever that discussion was. And I think it was about a Chapter 110 variance. A Chapter 110, the general zoning code, does not allow lot width variances currently under Chapter 110.
Correct.
What you have before you is a Chapter 98 variance, which is the subdivision law. And what is the general purpose of the subdivision law? And that is to create developable lots. So developers can create them in a variety of different ways, and they can request variance to lot width under Chapter 98 when they're either doing a lot split or a plat.
We used to have a procedure where we went through and approved plats. People would build townhouses, four units in a row. The interior ones were different lot sizes than the two ends.
Right.
We came along and the plot procedure was go ahead and build your units according to code. Then when you finally get them built, you built that under the preliminary plot. And then when you got them built, you measured the exact measurements and you submitted those for the final plat. And the lot sizes were adjusted. And then they were signed off on the final plat.
Right.
So we have changed lot sizes by hook or by crook or by legal or otherwise, but we have done it.
But during the plat process, which is
Yes.
Chapter 98.
Yeah.
Right, it's not Chapter 110, it's a Chapter 98
Yeah.
variance.
Yeah.
So you're correct, your recollection is correct. If your context is townhouses have to be platted.
Right.
So that's,
Yeah, and Mr. Campbell is correct, too. There is a definition in 110 about variances, but we're not dealing with 110 here. And that's why I was very clear when I first started reading my staff reports, we're dealing with a Chapter 98 variance. Where typically we get caught up in 110 variances because we do them 99% of the time.
Okay, I'm going to try to bring this to a close. I'd like to get a vote and submit it to the council and see what we can do with it. That first variance was the orientation. Read that for us again. We're going to vote on it to approve it or not approve it.
Yes, Mr. Chairman, if you go to the recommendation to the city council section of our staff report, which is page 6 of 6, it outlines exactly what we're suggesting the board do. And it's one, the modified, make a recommendation on the modified lot split plan and the following corresponding variances. One, a variance of 25 feet to the required width.
Wait, we're getting buried in data again. What is this orientation? In a nutshell, what is it telling us we can do? What should it be?
There's really not a variance to any orientation language.
It should be avoided. There should not be
Okay,
two.
that's the double or reverse. The 2C says, "A variance to the provision that the creation of double or reverse frontage lots should be avoided as it relates to the corner lot." So we're
What's the
asking for a
variance
variance to
asking
that,
for? The variance is asking
to
for
that
what?
language, that a reverse or double lot should be avoided. We're asking for a variance from that language.
Do you have a copy of the variance in front of you, the actual variance filled out by the application?
Yes, it's in your agenda packet.
Okay, I haven't covered it because I couldn't get it out of my computer.
Okay.
All right. I assume the rest of us have a look at it. I'm going to ask you to put a motion on the floor to recommend approval or disapproval of that variance request for, what do you call it, double orientation?
A double or reverse frontage should
Okay.
be avoided. We're
Thank
asking
you.
for the variance from that
That's going to
language.
show up funny in the minutes. Thank you, Kim. Now, I'm not going to take time to read that because I'm trying to do business and I'm going to have,
Just number 3, sir.
what?
They're 1, 2, and 3, that's the applicant's request.
Double and reverse frontage lots should be a 4. Okay. I'm going to ask for a vote on approval or disapproval on the variance requesting double and reverse frontage lots. So can I have a vote or a motion to recommend approval or disapproval?
I'm not sure how to word it.
Okay, I'll put a motion on, I'll try to, no, I'm not. I usually write those out before I try to word them complicated.
I could suggest some language if you'd like.
What?
I think all we need to do is just say a variance to the provision that the creation of double or reverse lots should be avoided.
Okay,
that simple.
I'm going to assume that goes in the record, and I'm going to ask for a motion to recommend approval or disapproval of that provision.
Mr. Chairman, I'd like to recommend a motion to vote on this.
Okay?
Stephen, is that for approval or denial of that?
For
language?
approval.
Are you going to, you're going to
Right, for approval.
recommend approval?
Yes.
Okay, we have a motion on the floor to recommend approval of that variance request. Madam Secretary, would you call the roll?
We'll need a second on that.
Oh, I'm sorry, thank you.
I'll second that motion.
Okay, now we have a motion and a second.
Mr. Russell,
Against?
Mr. Price,
For the motion.
Ms. Denny,
For this one, I'll say 4.
Ms. Gentilcore,
Against the motion.
Dr. Miller,
For the motion.
Mr. Stroud,
For the motion.
Mr. Thorpe.
For the motion.
Okay, that motion is approved. We now, okay, we recommend approval of the double and reverse frontage lot variance. Second variance, recommend approval or disapproval of the 62 feet width to the minimum 75-foot width. In other words, we're going to approve 13 feet. How do we word that?
Mr. Chairman, I would suggest something like this: a variance of 13 feet to the required width of 75 feet for the proposed northern lot.
Okay. Assume that wording goes into the record. May I have a motion to approve or disapprove?
I make the motion to disapprove.
Is there a second?
I second it.
Would you call the roll?
Mr. Russell,
I am, what was the motion?
To disapprove.
Disapprove it? I am for disapproval.
Mr. Price,
I'm against the disapproval.
You're for disapproval or against disapproval?
Against.
Okay, against the motion.
Ms. Denny,
For,
Ms. Jenicoor,
Or,
Dr. Miller,
For.
Mr. Stroud,
I'm against.
Mr. Thorpe.
For approval.
Okay, what was the vote? I didn't count it. Is it approved or disapproved, Madam Secretary? It was approved, all right? That variance is recommended to be approved.
no, the variance
It's
is
a
recommended
negative,
to be
unfortunately, it was
disapproved.
a negative motion, which,
It was a negative motion,
it was
so
a negative motion, so if you
That's why I
voted
stated
for
I
it,
was
you were
against
voting
negative
against
for you.
the variance.
well, you voted, well, okay.
Let's back up, and what did we do?
Do you all understand what that
Approved
was?
to deny, okay.
Yes, it was denied.
All right, and the first variance to on the 15% rule, what was that? 15% of the southern lot?
Yeah.
To add,
I'll make a, mis-
what did that do? To get that, you had to change the dimension. What was the variance for? To change the dimension?
yes, well, yes, it would be, this would be under paragraph A variance of 25 feet to the required width of 115 feet of the proposed corner lot.
Okay, that's a long motion. I'm trying, I guess I'm going to just say, is there a motion on the floor for approval or disapproval of variance of 25 feet?
Mr. Chairman, I'd like the motion to approve that variance.
Okay, is there a second?
I'll second that motion.
Okay, and we have a motion and a second. Would you call the roll, please, Renee?
Mr. Russell,
I'm against it.
Mr. Price,
For the motion.
Ms. Denny,
Against,
Ms. Jenicoor,
against the motion.
Dr. Miller,
Against.
Mr. Stroud,
For the motion.
and Mr. Thorpe.
For the motion.
How many votes for and how many against? It passed or failed?
Failed.
The motion failed. All right, what have we got here? Let's rack it up then. The first variance on 25 feet failed. The second variance on 13 feet failed. And the third variance on the lot configuration was approved. Now, back to the city attorney. We've got two variances, recommend approve and one against.
No,
Two against.
opposite.
Two against
You have
one.
the dimensional variances, have you voted to recommend denial. The only one that you recommended approval is a desire provision in the code about double frontage and reverse frontage lots. So now, you either have other suggestions or, a motion to recommend denial of the modified lot split plan would be in order because it can't survive without the variances.
Okay, thank you for clarifying that.
I have a point of order. There's actually no action on the first variance because the motion to approve didn't pass. Don't you need a motion to deny?
I'm not following you there. The first,
The A variance was there was a motion to approve, which was denied. Don't you need a motion to deny now?
the first motion was regarding the variance to the provision that the,
I'm talking variance A on your
The
staff.
last one
The last
was
one we
voted on.
voted on.
There was a motion to approve that did not pass, so there's been no action technically on that variance. I
yeah,
would think.
I mean, there's 4 against, so you could, I don't think a motion is necessary, but if you want to make a motion to deny the first variance, which is a variance of 25 feet to the required width of 115 feet of the proposed corner lot. That would be in order. This way you would be on record rejecting that variance as well.
Okay, do I have a motion to deny the variance on 25 feet?
I'll make a motion to deny the variance on 25 feet.
Thank you. Is there a second?
I will second that.
Now let's have a vote. Renee, call the vote.
Mr. Russell,
I'm for denial.
Mr. Price,
Against.
Same thing.
Miss Denny,
Or,
for denial,
yes.
For the motion, yeah.
Miss Gentilcore,
For the motion.
Dr. Miller,
For the motion to deny.
Mr. Stroud,
Against.
Mr. Thorpe.
Against the motion.
Where does that leave us? Did it pass or fail?
Motion passed.
Motion
Motion for
passed
denial
to
passed.
deny the variance.
Denied it. Okay.
Now you would need other,
That's why I always write my
Motion to-
motions down in longhand before I even put them out. Let's don't do this again. If we're going to do multiple variances, we will sit down and we will write how to put them on the floor.
now you need a vote on the modified lot split plan.
All right, is there a motion on the modified lot split plan?
Mr. Chairman, before we take this vote, can I make a comment?
Sure.
So, Mr. Russell and myself have been on this board for some time, Mr. Russell a lot longer than me. But this board, since I've been on the board, has approved variances for lot splits. We've approved variances for houses to be built on non-conforming lots. We've done a lot of things, all with the intention of making the city of Cape Canaveral better. I'm not going to say whether I think approving these lot splits would make the city better or not, but I ask that everybody on this board consider the city. Thank you.
Thank you, John. Okay, now we're asking for a motion to recommend approval of the lot split plan. Approval or disapproval? We'll make a motion, need a motion to recommend. We have already denied the two of the applications. It wouldn't be sensible to recommend approval of the lot split plan in view of the denials we voted for.
No, it can't survive. The lot split plan can't survive at this point.
So we need a motion to deny the lot split plan.
Mr. Chairman, I make that motion to deny the lot split.
Thank you. Is there a second?
I'll second the motion.
And there's a second. Renee, would you call the roll?
Mr. Russell,
I'm for the motion.
Mr. Price,
Against.
Miss Denny,
For the motion.
Miss Gentilcore,
For the motion.
Dr. Miller,
For the motion.
Mr. Stroud,
Against the motion.
Mr. Thorpe.
Against the motion.
Okay, so according to the vote, we recommend to deny the lot split plan to the council. Okay, zoning is not easy. I thank you all for your attention, your energy and time that you put into this. It's been a thorny issue. And it will not go away. We'll visit it again, I'm sure. But again, thank you. And is there any further business to come before the board? Hearing none, the Planning and Zoning Board is adjourned.
Welcome back.
That was hard.